A 27-year-old worker named Arnold was assigned to a warehouse roof replacement in Salford. He had never worked on a roof before. This health and safety executive report confirms his employer, Lee Harper, prepared no safe system of work. There were no safety nets or harnesses. Arnold stepped onto a fragile skylight, falling 6.75 meters to the floor below, dying from his injuries. During the subsequent trial, Lee Harper stated plainly to the court that he had not given any thought to health and safety measures prior to the incident. When a death occurs under these specific conditions, the legal system faces a complex problem. The person who directly causes the death is at fault, but there are underlying organizational reasons that contribute. To establish liability, the law splits this single tragedy into two entirely separate criminal prosecutions. To correctly analyze corporate homicide, we must use a dual-track liability matrix. Track 1 focuses entirely on the company as a distinct legal entity. This relies on statutory law, specifically the Corporate Manslaughter and Corporate Homicide Act of 2007. Track 2 focuses on the human actors. This relies on the common law offense of gross negligence manslaughter, holding individual directors or managers personally responsible for the death. Mixing these two tracks is a critical error. Individuals cannot be convicted of corporate manslaughter. It is an offense designed exclusively for organizations. To see how this dual-track system operates in practice, we will evaluate the legal exposure of the organization first, before turning our attention to the liability of the human director. Before 2007, prosecuting companies for death was difficult. In 1987, the Herald of Free Enterprise ferry capsized in Zeeblach Harbor, drowning 193 passengers and crew. The subsequent investigation revealed that the ferry sailed with its bow doors wide open. The operating company had installed no warning devices on the bridge and maintained inadequate safety systems. Despite this, the prosecution of the ferry owners failed entirely. Looking at this text detailing the historical context, the failure stemmed from the identification principle. To convict a company of manslaughter, prosecutors had to prove that a single senior executive, the directing mind and will of the company, had the necessary mens rea for the crime. In large corporations, information is highly siloed. If several executives knew pieces of a safety risk, but no single individual knew the full story, the identification principle failed. The company walked free. The Corporate Manslaughter and Corporate Homicide Act of 2007 was enacted specifically to remove this hurdle. It entirely discards the need to find a single guilty directing mind. Under Section 1 of the Act, an organization commits an offense if its management meets 3 criteria. It causes a person's death, amounts to a gross breach of a relevant duty, and a substantial element lies with senior management. Section 2 defines a relevant duty of care. It relies entirely on existing civil negligence law. An employer naturally owes a duty of care to its employees regarding the systems of work and equipment used. Establishing whether this duty exists in any specific case is a strict matter of law. It is decided by the judge, not the jury. The jury's task is to determine if a gross breach occurred. Under Section 1.4, conduct is a gross breach if it falls far below what can reasonably be expected of the organization in those circumstances. Section 8 instructs juries to evaluate the organization's corporate culture. They must look past written policies and examine attitudes, systems, or accepted practices that tolerate health and safety failures on the ground. If a gross breach is established, the normal legal principles of causation apply to link that specific management failure directly to the death. Liability under the 2007 Act rests on the collective failure of the organization's management systems, aggregating the faults of multiple decision-makers into a single corporate prosecution. However, a company cannot be convicted unless a substantial element of the breach is driven by how activities were managed by its senior management. This excerpt provides practical examples of the statutory definition found in Section 1.4c. A local supermarket bakery manager does not qualify. A regional director overseeing a substantial geographic division likely does. The Act targets 2 specific strands of responsibility: those making the high-level strategic decisions and those executing the actual hands-on organizing of a substantial part of the company's activities. Applying this framework to our warehouse case, Lee Harper is the managing director of Harper Building Contractors Limited. He dictated the terms, timing, and resources for the Salford project. His failure to implement safety protocols, like netting or harnesses, was not a localized error by a junior supervisor. It was a strategic failure at the highest level of the company's decision-making process. Because Lee Harper's actions satisfy the definition of senior management, Harper Building Contractors Ltd. is directly vulnerable to a Section 1 conviction for corporate manslaughter. While the company faces Track 1 statutory liability, the human actor who caused the failure faces Track 2 common law prosecution. For Lee Harper as an individual, the relevant charge is gross negligence manslaughter, governed by the test established in the case of Adomako. The first requirement is a personal duty of care. As the employer directly supervising the worksite, Harper owed an undisputed duty to Arnold. This report explicitly outlines the breach. Harper sent an untrained man onto a fragile roof structure without establishing a safe system of work, providing safety harnesses, or installing catch nets below. To secure a conviction, the jury must conclude that sending a worker into that environment with zero protection was so grossly negligent that it requires criminal sanction. The causal link is direct. The absence of those specific, legally required safety systems is exactly why the 6.75-meter fall proved fatal. The facts of this single event yield two independent convictions. The organization is liable for the systemic management failure, and the individual director is liable for his personal gross negligence. When an organization is convicted of corporate manslaughter, it cannot be imprisoned. The primary penalty is an unlimited fine. This sentencing text explains the calculation mechanics. Courts assess the foreseeability of the injury and the size of the company. A micro-organization faces a minimum fine of £180,000, while large organizations with turnovers exceeding £50 million face fines up to £20 million. Additionally, under Section 9, the court can issue a remedial order. This legally mandates the organization to review and overhaul the dangerous policies and procedures that caused the death. Failure to comply with a remedial order is an entirely separate criminal offense, punishable by further financial penalties. For smaller entities, the economic reality is stark. In the first conviction under the Act, a geotechnical firm was fined £385,000. Despite being allowed to pay in installments, the penalty forced the company straight into liquidation. Beyond financial ruin, Section 10 grants the court power to issue a publicity order. This enforced name and shame mechanism means the convicted organization must publicize its offense, its conviction details, the fine size, and its remedial orders. This goes far beyond just standard press coverage. It attaches a severe public stigma directly to the brand, causing immediate adverse consequences for future business, investor relations, and share prices. In 3 decades, the law has moved from a state where large corporations were virtually immune to prosecution due to the identification principle to a rigid statutory framework under the 2007 Act. To correctly analyze liability today, the tracks must be kept isolated. Apply the 2007 Act to the organization's collective failure, and apply the Adomako test to the individual's gross negligence. Together, these frameworks dismantle the old defenses, ensuring that when safety systems collapse, the law holds both the corporation and its directors strictly accountable.